Hello, everybody, and welcome to this Brennan Center for Justice event, a very special event on a big day. For those of you joining us for the first time, the Brennan Center for Justice at NYU School of Law is a nonpartisan law and policy institute. We work to reform, to revitalize, and when necessary, to defend the systems of democracy and justice so they work for everybody in this country. This challenge, this mission is more important, I would submit, than ever. I am Michael Waldman. I am president and CEO of the Brennan Center. Before we get started with this interesting conversation, I want to share a few general principles for how we want to proceed. First of all, civility is very important to us all. If you post intemperate language in our message streams on YouTube or Facebook, you will be removed from the conversation. Live closed captioning will be provided, and please follow along with the conversation on social media with the hashtag Brennan Center Live. Now for the conversation that we're having, which of course happens at a pretty dramatic moment, literally as Sidney Powell has turned herself into authorities in Atlanta, Georgia, and Rudy Giuliani is on his way there to do the same on an important day that has riveted all our attention. In a lot of ways, this is a pivotal moment for democracy, and it is certainly, we think, an unprecedented one. First, you had the unprecedented phenomenon and fact of a defeated president trying to cling to power, trying to undo the peaceful transfer of power and reject the results of an election. And now, two separate criminal indictments, one federal, one in state court, revolving around those matters. Each of these would be the trial of the century, and there may be two trials of the century relating to this. In the federal indictment relating especially to the events leading up to January 6th, Donald Trump has been charged alone. In the Georgia indictment, he is charged along with 18 co-defendants. This is all a very big deal. None of this is news to any of us. We're all buried in an avalanche of conjecture, of analysis, of discussing the implications of what this means for our democracy. We want to stress today that we're not really looking at the impact of this on the elections of 2024, on the debate in the primaries tomorrow, or any of those things. What we really want to look at is the implications of these charges, the implications of these cases for American democracy, for voting rights, for orderly administration of elections, for the integrity of elections, and the health of our Constitution. The title of this event really says it all. Donald Trump is not being put on trial alone. The big lie, the notion of widespread fraud in our elections, which undergirded his efforts to cling to power, but which have been so significant in so many ways in states and nationally all over the country, the big lie is also on trial. So for the work the Brennan Center does to try to protect and improve our elections, it's doubly significant in that way. These are important topics. These are complicated topics, and we're really lucky to have to help us understand and illuminate these topics some of the country's leading experts. First, I want to introduce two scholars, my colleagues from the Brennan Center for Justice. Sean Morales Doyle is the director of our voting rights program, a leading author and litigator on voting rights issues all over the country. And Gauri Ramachandran is the deputy director of our elections and government program, and she focuses in particular on working with election officials, on the attacks on election officials, and on addressing the flood of disinformation that has so saturated our society and our elections. And joining my Brennan Center colleagues, we're very pleased to have with us Andrew Weissmann, who is known to so many of you. He is a professor of practice at the NYU School of Law. He was general counsel of the FBI and the principal deputy to Robert Mueller when he served as special counsel. He is the author of the book Where Law Ends, and you probably recognize him from his service. of us. We hope he will do that for us this afternoon. So I want to start by saying welcome to all of you. We have a ton of questions, by the way, from people watching, and we will be asking as many of them as we can. But I want to start with you, Andrew Weissmann. First of all, again, thank you to you for being here. If you could take us with as wide a lens as possible about these two separate sites. As I said, the federal government dealing with so many of the issues that the January 6th committee, for example, spelled out, is focused on Trump, on Donald Trump, whereas the Fulton County indictment involves many more people. What do you see as the significant difference between these two potential trials, and are there things we should understand about their significance in that way?
Well, thank you so much for inviting me. I'm a huge fan of the Brennan Center and the work you do, so it's a real privilege to be participating today in a small way as part of your endeavor. So I think there's a lot that is really in common between the federal so-called January 6th case and the state January 6th case. One has, obviously, the federal one has in some ways a broader lens. It does a deeper dive into what was happening at the White House, what was happening with Mike Pence, what was happening in the Department of Justice, and a bit of a deeper focus on what was happening outside of the states of Georgia. But the Georgia case is really remarkably similar, and it does a deeper dive into essentially taking us inside what was happening on the ground in a specific state, so that we could see the break-in into the electoral actual machines. We could hear about and read about the granular harassment of Ruby Freeman and Shay Moss. There was sort of more granular details about how a scheme that is alleged to have happened, orchestrated from Washington, got implemented on the ground. So I do think that they're similar. They have slightly different focuses. I think that the key difference is one that may become quite important, which is that the state charges against all of the defendants remain regardless of who wins the presidency, because those state charges cannot be federally pardoned by a president. And that is true even if some of the defendants are successful in moving the case from state court to federal court. The charges are still state charges, and they remain not subject to a federal pardon. I would make one brief caveat, which is that if Donald Trump, who is a defendant in the Georgia state case, were to win the presidency, there is a substantial legal argument that and he certainly will make the argument, that the Georgia state case should be on hold as to him. But the case could still go forward as to the other defendants, and they would not be subject to either a stay or a pardon. So that, I think, is the sort of, to my mind, is the key difference. Obviously, if this Georgia case stays in state court, one other, I think, salutary benefit to the public is that Georgia state trials are generally televised. Federal trials are not televised. So the Georgia case, if it remains in state court, is one that all of us will be able to see for ourselves. And I do think that is going to be really important, very much, Michael, to your point about sort of how do we tackle the big lie on trial. I do think that I'm not naive. I don't think televising means that the magic wand suddenly means everyone's sees the truth and recognizes the truth. But I do think that for many people, it will have that effect.
If there is a televised tableau of Mike Pence under oath saying the things that he's said in the various indictments, for example, that would be pretty riveting. One of the questions that comes from the audience is relating to the way the Georgia case was charged using RICO, the state analog to the federal racketeering law. It's a lot of defendants to cram into one courtroom. What is the significance of this being charged as a racketeering case, a type of conspiracy law? And are we really likely to see a trial with that many people in one room?
Well, let me tackle the last. The DA has said that she wants to try them all together and she wants to try them soon. Personally, having been a prosecutor for over 20 years, I've also been a defense lawyer. I actually think trying 19 people together is a gift to the defense side. I think it creates a bit of a circus, and I just don't expect that that's going to happen. At the federal level, there's actually kind of a presumption of prejudice when I think the number is over 10 people. But it's just simply not great practice. And frankly, even from a sort of, you want the jury to be able to decide whether the proof is there beyond a reasonable doubt as to each defendant and as to each count as to each defendant. If you have 19 people, I mean, that is just unwieldy. And it really, I think, is not great in terms of what you want the jury to do, but also just in terms of decorum and speed and having, a serious trial. I just think it needs to be done in bite-sized pieces. RICO is, I think too much has been made about RICO. Whether you think of RICO as a large conspiracy or you just charge this as a conspiracy case, I think it's largely the same. There obviously are different elements to a RICO than a conspiracy count, and those have to be proved. They have to be proved beyond a reasonable doubt by the state or the government. But in essence, the reason to charge a conspiracy is, as I think Fani Willis correctly said, is that she wants to put before the jury the whole story. And that's why I think it was really smart of her to allege what was happening, not just in Georgia, but in other states, so that they really could see this as a whole. If you were a juror and you were just told this was an effort in Georgia, you might say, well, why would they just do it in Georgia? It wouldn't have the necessary effect on the federal election. So she really wanted to make sure she encompassed the entire scheme, as did Jack Smith. So RICO allowed her to do that. A large conspiracy would have allowed her to do it. She obviously has a history of bringing RICO cases, and so I think she's very comfortable with that in different circumstances. But again, it could have been done under a different statute as well.
You mentioned Jack Smith, and of course, he is the special counsel who brought both the case relating to documents, but also the January 6th case. And you've been quoted in the media as saying you thought that the indictment as drawn up in the January 6th case, calling it that in shorthand, was particularly strong. One thing that was noteworthy was how much effort was made in the charges to make clear that Donald Trump knew that he had lost the election and knew that these were lies. Why was that legally important, and why? And is the court the only audience there?
So there'll be I think there's going to be quite a discussion on the issue of whether it's legally necessary, because it's not clear to me that all of the charges would require the government to prove that Donald Trump knew that he had lost the election. Let me just give you an example. If Donald Trump had been charged with actual engaging in physical violence himself on January 6th, you wouldn't be able to, as a defense, say, but I thought I won the election. That might be, even if it were true that you thought that you won the election, it doesn't entitle you to use physical violence on January 6th. So I'm not sure that it will be legally necessary, by which I mean that the jury may be instructed by Judge Chutkin that they do not have to find, as a matter of law, um, that the defendant believed one way or the other whether he won the election. And in fact, if they found that he did win and it was unfairly kept from him, that actually might be a motive for him to have engaged in the crimes charged. The reason I think that it's important in the indictment is for two reasons. One, just because it's not an element or may not be an element of the crime doesn't mean that you don't want to prove it up. Think of it as in terms of motive evidence. You don't have to prove motive in a federal criminal trial, but a lot of times, if you have good proof of motive, you want to put it in there. Think of somebody who inherits lots of money when somebody dies, and you're trying to prove that they killed the person who died. If you can show that they were going to inherit millions and millions of dollars, you're going to want to put that in. It shows a motive to have committed the crime. So here, I think it is obviously extremely good evidence, but it may not be legally necessary. I do think that, Michael, to your the point I think that's buried in or implicit in what you were saying is that it does speak to a larger audience, and I think it's notable that both Fani Willis and Jack Smith started their indictments that were presented to the grand jury and voted by the grand jury by saying Donald Trump lost.
In almost identical language.
Exactly. And so I think it's really important, and it goes to very much the title of our why we're here today, which is calling out what is a big lie.
And the analogy that I use is that I may genuinely believe the money in a bank should be mine, but that doesn't mean I can stick up the bank and use that as a defense. But it is emphatically the case that the predicate for all of this is that he lost the election, and that there was an underlying lack of legitimacy to so much of what went on here. That's a really important point, and we'll color that in a little bit with my colleagues. Thank you. Let me turn to Gowrie. One of the ways that this big lie has played out is in a growing torrent of abuse toward and challenges toward election officials and the machinery of our elections. And again, it didn't start with Donald Trump, but it has been greatly amplified during this time. Your work centers in many ways, Gowrie, on election security. What were some of the laws that he is accused of breaking as relates to, first of all, election officials and the abuse heaped upon them, and also not just the machinery of counting the votes, but also certifying the electoral votes?
Well, as it goes to election workers and abuse and threats against them, I think it's so important that this indictment in Georgia names some co-conspirators who engaged in threats against election workers that Andrews mentioned, Ruby Freeman and Shay Moss, because it really puts people on notice. Threatening and intimidating election workers for doing their job is a crime, and you can be held accountable for that. So it's so important that the public be aware of that and be notified about that. We've conducted multiple surveys at the Brennan Center of local election administrators. And unfortunately, since 2020, they have faced a real torrent of abuse and threats and harassment merely for doing their jobs. We've also found that these threats and harassment are one driving factor in an exodus of experienced election officials from the job. And our research has found that we believe that about 1 in 5 local election officials will be administering their first presidential election in 2024 because of that exodus. So it's so important, not just because, as a sort of moral matter, to call out this terrible behavior, to say that election workers are heroes and they don't deserve this abuse, but also for our democracy to make sure that people are held accountable, and that will uplift election workers and remind them that their incredible hard work is so appreciated by us all. I'm hopeful that in addition to things like this indictment, we can also provide funding from state, local, and federal governments and other resources to help them do this really important job.
You know, it's an interesting thing. The question always is, do these prosecutions deter conduct, bad conduct? One of the things that has been noted is that in recent months, when the former president has summoned his crowds to protest or raise a ruckus at various courthouses, people have not showed up, and one has to imagine that the volume of prosecutions of people after January 6th might have given some second thoughts to some of the people who might otherwise act out. You know, why is it in this case potentially criminal for somebody to say to state legislatures, to say to secretaries of state, hey, I really won the election, or hey, you know, you should certify the electoral votes a different way? Is that not just part of the normal push and pull of the political process?
I would say no, it's not normal. So imagine, you know, this famous phone call many people have seen the transcript of or listened to, in which former President Trump asked Secretary of State Raffensperger in Georgia to essentially find him a bunch of votes to throw out so he would win the election. Imagine if Secretary Raffensperger had actually done that, had actually heeded that call. You would hope in a democracy that that kind of behavior would be illegal. And the good news is we do live in a democracy, and that is illegal. So in Georgia, it is a felony for public officials to violate their oath of office in that particular way. And all public officials in Georgia take an oath of office to uphold the Constitution of the United States and of Georgia. And both of those constitutions secure the right to vote, to have one's vote counted. So it would have been a crime to do that. And it's also a crime in Georgia to solicit that crime. So solicitation of a felony in Georgia is itself a felony. So it absolutely is a crime to ask somebody to throw out a bunch of people's votes with no reason. It's also a crime under federal law to conspire to violate others' fundamental rights, including the fundamental right to vote. I'm sure that my colleague Sean is going to have a lot to say about that particular statute.
And again, this is where, as Andrew Weissmann said, the first sentence of each of these indictments is so important. Donald Trump lost the election, and that changes the whole concept of what it means to try to get them to, quote, find the votes to change the result. One last question for you, Gary, before I turn to Sean. In the Fulton County indictment, there was one sort of new set of facts that had not really gotten so much attention before, which had to deal with the accessing of, allegedly improper accessing of election equipment by people involved with the Trump campaign. What's the story there, and why is that important?
This is really important because, unfortunately, this incident in Coffee County, Georgia, in which voting machines and the election management software that's used to sort of collate all the votes together, unfortunately, this incident in which those machines were accessed by partisan people with nefarious aims, unfortunately, it's not an isolated incident. There have been at least 17 attempts that we've tracked nationwide to improperly access equipment in this way. So it's super important that people who allow this improper access be held accountable, because that sort of security breach is very dangerous. And it really damages our democracy in two different ways. One way is that when nefarious actors obtain images of software or people's personal information, or they tamper with equipment, they can take video of that and images of that, take it out of context, and use it to spread further conspiracies. So, for instance, some images that were taken of data from Mesa County, Colorado, were used by Mike Lindell and some of his fellow election deniers to spread conspiracy theories about the machines that are in use in Colorado. They didn't actually find any evidence of anything wrong with those machines, but they used those files to spread conspiracy theories. Another way that these breaches are damaging is that they can cause actual direct damage to election infrastructure. So it's believed that at least one of these attempted breaches in Michigan caused unintentional damage to the voting equipment. You could also have, when you have partisan actors who are clearly willing to go to all kinds of lengths in order to overturn an election and get their way, you could have those folks inserting malware into these systems when they're given this unauthorized and unsupervised access. And it's for that reason, actually, that many state officials have decommissioned equipment after these breaches have come out. So it's really important that this particular breach in Coffee County is being prosecuted for that deterrent effect that you mentioned, Michael.
This is really almost absurd dystopian stuff. That's fascinating. Thank you, Gary. Sean, I want to go back to the title of this event, The Big Lie on Trial. So many of the conspiracy theories, so many of the false charges made and detailed in both the indictments deal with allegations of voter fraud, of dead people voting, of ballot dumps, of all these things. And as you know, this is not something Donald Trump invented, these allegations. This has been building over many years, and the Brennan Center has been very involved over many years in rebutting and repudiating the myth of widespread voter fraud. Why is this important in this case and more broadly, in your view?
Well, it's important in this case because it is, the justification that Trump and his co-conspirators were giving for, why they were taking the extraordinary and allegedly illegal actions that they were taking. It's important in a bigger picture because, as you say, this isn't new. This has actually been sort of a fight, a lie that's been at the heart of a fight over our democracy now for more than a decade. And really, actually, much longer than that. It's not actually that new. It's not new at all in our country for people to make up lies about voter fraud and fraud in elections in order to justify, not only to justify misbehavior, but to justify very specifically the misbehavior of trying to get in the way of people exercising their right to vote. That's what these indictments really come down to. What they're really all about is Trump taking this tactic of using a lie that there is rampant fraud in our elections to justify depriving people of their right to vote. That's what's been going on for the last decade in this country. That's why we've seen, law after law passed in states around the country restricting access to voting. Those laws are often justified based on this lie about fraud and then are used to stop people from voting. And Trump took that to a new level by taking this lie about fraud and using it to try to really toss out the votes of millions of voters around the country.
Now, you've written about this, that this, we make the point that you're more likely to be hit by lightning in this country than to commit voter fraud over many years. But it's not just everybody who's really targeted by this. Over and over again, these allegations implicitly or explicitly target voters of color. And when in all these places all over the country, the effort was made to throw out the votes of Detroit or Philadelphia or Atlanta, the racial subtext is not very subtle. You've written about this. One of the charges in the federal indictment that was significant was, as you've written about, is Section 241 of Title 18. This is a law, I believe, that dates back from the era of Reconstruction, and it's an important voting rights protection law. First of all, tell me if I got it wrong. But second, if I didn't get it wrong, if you could explain what this is, why it's relevant, and why it's appropriate potentially to use in a case like this.
Sure. So you didn't get it wrong. The law was passed originally in 1870. It was the first of a series of laws that were called the Enforcement Acts. And that what that meant, what that's a reference to, is that they were laws passed by Congress to enforce the Reconstruction Amendments to the Constitution, the 13th, 14th, and 15th Amendment. The 15th Amendment, of course, includes a prohibition on race discrimination in voting. So effectively recognizes the right to vote for, at the time, Black men or men of color. And the enforcement acts included a lot of different provisions that really were sort of Congress's first attempt at protecting civil rights in the United States. And Section 241, 18 U.S.C. 241, which is one of the statutes under which Trump is charged in the federal indictment, basically makes it a crime for someone to conspire to deprive someone of their federal rights, including the right to vote. These laws were also sometimes known as the Ku Klux Klan Act, because at the time, one of the ways that people were trying to deprive folks of their right to vote was through terrorism. It was the Klan going out and terrorizing Black folks to stop them from voting. And so I think when we talk about this as a Reconstruction era law and a law that is about, that was targeting the Klan, that makes people, it might strike people as something that sounds sort of arcane, or, it's what Trump is accused of doing here doesn't really remind people of burning crosses and, terrorizing people in the streets. But it's important to know that this law, because it really was sort of foundational in the nation's first attempt at trying to protect civil rights, has a long history of being used to prosecute attempts at interfering with elections in all kinds of ways. More than a century ago, the Supreme Court made clear this isn't just about violence and terrorism. This is about trying to interfere in the outcome of elections in ways very much like what Trump is accused of doing here. There's a case in 1915 where the Supreme Court upholds an indictment indicting 2 election officials for trying to throw out the votes for 11 precincts in one county in Oklahoma. And what's interesting about that is, like Trump, those election officials, while their reason for throwing those votes out was baseless, just like Trump's reason for throwing out votes in the 2020 election, it wasn't aimless, just like Trump's was not aimless. As you said, Trump targeted the cities where Trump said this fraud was happening. It was a lie, but the places where he said it was happening were Detroit and Philadelphia and Atlanta and Maricopa County, Arizona. And that's not a coincidence, nor was it a coincidence in this case back in 1915. The precincts that were targeted in that case were precincts where a grandfather clause was not enforced, and so Black folks were actually able to vote. This statute is significant, and it's significant that Trump was charged with it, because it ties this fight over our democracy back to fights throughout our nation's history over our democracy, which are often fights that at their heart are really fights about race and who it is that we should be including in our democracy. And I also just want to add on, that fight has often also included these lies. Often the lie that has been used to justify excluding certain people from our democracy has been a lie about rampant fraud. The folks that were trying to enforce grandfather clauses in the early 20th century were doing so because of claims that Black voters were more subject to bribery and things. And so we would clean up corruption in our elections by enforcing these laws. So what Trump's accused of doing here is anomalous and new and something none of us really experienced before, but it really does echo some of the fights that we've had over our democracy over the years, including the one that led to the passage of 241 back in the 1870s.
Sean, that's so important what you've just said, and so well explained, and a really important thing for us to keep in our minds as we look at all of this. I want to bring the questions in even more from the audience as they've been coming in, and I want to start actually, Andrew, if I could, with you. One question that a number of folks have had relates to: will the U.S. Supreme Court ultimately be involved in this? Trump has already sort of on social media demanded their involvement. One area, for example, where there may be a more colorable claim to a constitutional question is that all this activity took place while he was president. He was also a candidate for office, but he was president. And the question which you alluded to, that it is assumed by folks who work on this that a sitting president cannot be on trial. But the Supreme Court has actually not ever ruled on that, I don't believe. And in in, for example, the Nixon versus Fitzgerald case, gave a pretty wide berth to almost immunity for presidential conduct, and said that the criminal cases or civil cases are not the way we police presidents. Do you think the Supreme Court's going to get involved? I'll ask my colleagues the same question. And in particular, do you see that issue of presidential immunity as a real debate?
So I do think that there are a lot of novel issues that the Supreme Court could very well have to deal with, some more pressing than others because of the fact that we are in uncharted territory with respect to the first ever criminal charges against a former president. He is actually under indictment for crimes that are alleged to have occurred before, during, and after his presidency. And so one of the issues is if he were to regain the presidency, what happens to any charges that are not dismissed? Obviously, the federal charges he would be able to just make go away by just ordering his attorney general to get rid of them. He wouldn't even have to pardon himself. But for the state charges, there's a question of whether there would be sort of a stay of those cases. There's also the issue, Michael, that you've alluded to, which is presidential immunity. That immunity argument is being made currently by some of the defendants in the Georgia case who are seeking to remove their cases to federal court and claiming that the conduct is immune because they were acting within the scope of their office. I think that is a hard argument to make. Obviously, the indictments, the federal and state indictments in the January 6th case, if they are to be believed and if there is evidence to support them, are crimes that are antithetical to the oaths of office that those federal officers took. It is, this, to state the obvious, it is not part of your oath of office to engage in a coup. It's not part of your oath of office to threaten the Secretary of State of Georgia with criminal prosecution if he doesn't find the requisite number of votes. So you would have to be able to convince a court that that the conduct at issue was consistent and part of your duties as a federal official. But that's an issue, and I think that is one that's going to be litigated sooner rather than later because of these removal actions in Georgia. And then there's a third area where the Supreme Court could get involved, where if they do get involved, it I think has to be very quickly. And that is the issue that two professors wrote about in the University of Pennsylvania Law Review. Judge Ludig and Lawrence Tribe have written an article in The Atlantic on the same issue, which is whether Donald Trump is simply not eligible to be president because of the 14th Amendment, in that he engaged in insurrection or rebellion. That raises a whole host of legal issues that are undecided, but that is one that could come to the fore and presumably is one that the Supreme Court would want to rule on prior to the Republican convention.
So I thank you for bringing that up. I want to turn to that and many of the questions that our viewers asked related to that. To remind folks, the 14th Amendment, Section 3 says that somebody who has taken an oath to uphold the Constitution and then engages in insurrection or rebellion is ineligible to serve in an office, including that of president, also in Congress. And their legal questions have been raised by two prominent conservative law professors who've said that he is ineligible to serve, and echoed, as you say, by Judge Ludig, who was the esteemed conservative federal judge, almost appointed twice to the U.S. Supreme Court, who was the person who advised Mike Pence that, no, you can't actually throw out the results of the election, but was such a powerful witness an emotional witness in front of the January 6th committee, as well as Lawrence Tribe, who's of course the renowned over many years liberal law professor from Harvard. The article, the Supreme Court will not adjudicate an op-ed. The article raises important questions. In a sense, you could almost say, and I'd be interested in everybody's views on this because none of us have experienced anything like this before. Even if it is clearly the case that he engaged in insurrection, for example, who decides that, and who has the power to block him from the ballot? The articles and the argument is that it's self-executing, that there is no need for an act of Congress or something like that to declare an insurrection to have been declared. There's precedent in the Supreme Court that suggests maybe you do need some formal act of government. Do we think this is, Andrew, do you or Sean or Gary, first of all, think that he engaged in the conduct that's covered, but second, who decides it, and ultimately are the courts the ones who are going to decide it?
I'll take an initial crack and then turn it over to our colleagues. So I think it's really important for people to first make sure they put this in a particular bucket. There's an issue of criminal liability, and that is whether someone's going to go to jail. This is a separate issue of whether someone's eligible to have the privilege of serving as the president of the United States or in any federal office. So with respect to that, they're really two separate issues. And you can decide one and you can still have a criminal prosecution. But I do think there are a lot of open issues. One is, what is the definition of insurrection or rebellion? That obviously is not defined in the Constitution. Two, to Michael, your point, who makes that decision? Does there have to be a criminal indictment? Presumably the answer is no, but it's not clear whether there has to be some finding and who would make it. And what is the standard of proof? Being lawyers, we always ask that question. Is it by a preponderance? Is it clear and convincing evidence? Is it beyond a reasonable doubt? Presumably, if you're going to take away our right to vote for somebody, and that's selecting somebody, that you would have to have some very clear standard and showing. Remember, Donald Trump has not been charged at the federal level with engaging in insurrection. So there won't be a finding even after the criminal case that he engaged in insurrection. There's the issue of whether it's self-executing or whether you need a criminal statute to sort of effectuate the language in there. And then the final point is, if there's any ambiguity, which way should that cut? Shouldn't it cut in favor of the person being able to be in office so that we have the right to vote for that person? Again, I'm trying to remove this from the issue of Donald Trump. I'm just thinking of it just abstractly. If there was any claim of anyone having engaged in insurrection or rebellion, how would we want that adjudicated in our system based on the rule of law?
Gary, you work with and think a lot about election officials, who would be some of the people who might be called on to make such a determination. How does that play out in your thinking?
To my mind, it's very clear that the nearly 10,000 local election officials across the United States do not want to be put in the position of making that determination. These are hardworking, often underpaid individuals who are dedicated to helping the voters in their community exercise their rights. They're not doing this for a glamorous job. They're not looking for the limelight. And in fact, many feel that they've really been unjustly thrust into the limelight after the 2020 election. So just as a policy matter, I don't believe that it's a good idea for local election officials to be tasked with making all of those determinations that Andrew was just talking about.
Do we feel differently about secretaries of state who are statewide or other people of that nature? Or is that a similar kind of conundrum?
I think for many of those individuals, it is a similar conundrum. Not all secretaries of state are elected officials. Some of them are appointed. The chief election official is in each state can vary by state. And so, it's not, a job in which people are seeking to be making that determination about whether somebody belongs on the ballot for president of the United States. Most election officials would like clear direction and clear instruction on those kinds of decisions because they really want to stay out of the partisan fray.
It's an interesting thing, though. Again, this is novel analysis any of us have to do because we haven't been in a situation like this before. But that 14th Amendment was, of course, written in the aftermath of the Civil War and that rebellion, and in the context of the Black Codes and the pushback against multiracial democracy that was beginning to emerge in the South. And the question is whether the laws Sean described are part of the 14th Amendment period as well. And we're basically, if the system needs to find a way to stand up against people who try to overthrow it. But it always goes back to the question of, do we really expect this Supreme Court to take that step of saying that Donald Trump is ineligible to serve? Sean, do you have any thoughts on this?
I would reiterate a little bit of what Andrew said and go back to something we talked about earlier, which is to say it's important for people to remember that Trump doesn't have to be shown to have engaged in an insurrection in order to be convicted under any of these indictments. And so these really are separate questions. You know, it isn't okay, as we talked about before, it isn't okay to deprive millions of Americans of their right to vote, regardless of whether or not you thought you won the election. And these prosecutors, you know, do a lot of work in these indictments to show that Donald Trump knew that he had lost. But whether he knew that he lost or truly believed maybe he won some of these states or whatever it might be, the 14th Amendment may talk about whether he's eligible for office, but immediately thereafter, Congress passed some laws that said, whatever your motivations, it's not okay to get in between people in their right to vote. And that's what he's accused of doing in these indictments.
So that points to a really interesting and important question. There is a way in which a presidential miscreant can be barred from seeking office, which is impeachment and conviction. And one of the challenges we face right now is that in the Constitution, the power of impeachment is very important. It was considered important by the framers at the time. If you look at the notes to the Constitutional Convention, they were debating it, and Ben Franklin actually said, well, the alternative is assassination. So this is probably a better system to deal with an abusive tyrant of a ruler. And for a long time, the prospect of impeachment was a real sort of Damocles hanging over the Oval Office. Richard Nixon resigned rather than face the ignominy of actually having an impeachment vote and removal. But in the last 25 years, of course, there have been 3 failed impeachments of Bill Clinton, who I worked for, and 2 of Donald Trump. And it seems clearer than it ought to be that impeachment turns out not to be ultimately the sanction that people thought it was for a long time, which leaves the criminal process, which has its own strengths, but its own flaws and weaknesses. Are we uncomfortable with the idea that the only way to hold a president accountable turns out to be the criminal law? Or is that not really the right thing to worry about? And I'll ask each of you to weigh in on that. Andrew, you were as mentioned at the beginning, deputy to Robert Mueller in the investigation of Russia's interference in our elections. I'm sure this is something you all thought about a great deal during that time.
Yeah, well, I mean, for the special counsel investigation of a sitting president, the Department of Justice has an internal policy. It's not law. It's internal policy that you cannot indict a sitting president. And I think it emanates from this idea that the remedy at that point in time would be impeachment, but that the person who is president could be charged after they are no longer in office. And so, for instance, if you thought that Donald Trump had committed obstruction of justice of our investigation, which I did think that he did, that's something that could have been charged after he left office. So that is one way to have accountability. I do think that I think it's appropriate for impeachment to be an incredibly high standard. You don't want it to be used in a cavalier way. We're seeing calls now for impeachment of officials up to and including the sitting president. And, that to me reads like a lot of political theater. And so it is important, I think, to have that high standard, even though it comes at a cost in terms of a remedy of removing somebody. And I think, some of that is our political system, which is, if you don't want that, is it the structure, or is it that you're really disagreeing with who's being put into office, and that they're not taking their oaths seriously? And so I do think at this point, because of that, the major way we have for accountability is the rule of law in this country and the ballot box.
And, if you remember Mitch McConnell, when Trump was impeached the second time for January 6th, McConnell said basically, yeah, he's guilty. I'm not going to vote to remove him, but he can be prosecuted for this.
Yeah, but Michael, there were a lot of people who said a lot of things that
Yeah.
day and shortly thereafter who no longer are saying it.
Mike Kevin is not leading the charge for prosecution anymore. Gary, you've said off camera that you're not troubled by the use of the criminal law here as the ultimate sanction.
Yeah, that's the case because in the Constitution, when it outlines the impeachment process and it puts some limitations on the kinds of penalties that can be imposed if someone is convicted during an impeachment process, the major one is removal from office. It follows that up by saying, but people can be prosecuted afterwards. And so other penalties can be imposed through that criminal prosecution, even though the types of penalties that can be imposed through impeachment are limited. So I think, I'm a textualist today, and right there in the Constitution, it comprehends the criminal prosecution of people who are also eligible to be impeached for wrongdoing.
I'll hold you to being a textualist next time the issue comes up. And Andrew, one of the questions from our viewers relates to this issue of obstruction. Is there a difference between the kind of obstruction that you found and the type of obstruction of justice implicit in these charges, though that was not brought as a charge here relating to these elections, I don't think?
Yeah, so I do think that a through line for Donald Trump is an obstruction of the rule of law, whether you're looking at it in terms of the obstruction of the special counsel investigation. The entire second volume of our report detailed that, and it was up to Congress to decide what to do with respect to the question you just put to it, which is, the impeachment on that basis or not. But people like Don McGahn, the former White House counsel, was a principal witness. And I think it's notable that I think in the trials that are going to be upcoming, the federal and state ones, and including the documents case, I think White House counsels are going to be key witnesses, as well as his own counsel. This sort of inability to follow the rule of law, including from his own lawyers and White House lawyers. But you have obstruction in the Mueller investigation. You have not one, but two types of obstruction charged in the documents case that are sort of real plain vanilla. And it's still remarkable to me that we're talking about somebody who is the leader of the free world, who is charged with two types of obstruction of justice. One involved lying to his counsel so that he basically so he did not have to comply with a grand jury subpoena. And the other is getting rid of evidence, tampering with a crime scene. And then there's a third type of obstruction, which is really obstruction writ large, and that is charged in both the January 6th federal case and the January 6th Georgia state case. And that is obstruction of Congress and attempted obstruction of the Georgia vote. And so that is really a through line of somebody who is an authoritarian or alleged to be criminally an authoritarian, who doesn't want to have a referendum for what he did in a forum where facts and law matter, and instead would prefer to simply have this adjudicated in a world of social and political speeches. I think it's the reason he's not debating. It's the reason that you have people saying that he should not go to court to do things, because that's just not a useful forum if you are engaging in the big lie. I think one of the things, just to get off my soapbox for a moment, but one of the things that I think he learned from challenging the election in court and losing in all of those was that was a mistake, because that's a forum where, as Amy Berman Jackson, a very respected district judge in DC, said, the courts are places where facts and law still matter. That's not a forum where, if you're engaging in a big lie, you want to be having an adjudication of what you're doing.
So to that end, I want to ask each of our panelists a lightning round question. What is the one thing you would like people to take away? What's the one thing you'd like viewers to walk away from this topic and conversation? And Sean, I'll start with you.
Thank you. I think what I want people to take away is to keep in mind that Donald Trump and his alleged co-conspirators, they really put our democracy to a test. The things that they're alleged to have done here put our democracy to a test. Our democracy proved resilient in the face of that test, but the threat that they posed is not over. This big lie led to a whole election denier movement that continues to threaten our democracy. So it's going to be really important to see whether or not the folks responsible for that movement are held accountable. But it's also really important that we continue to do the work necessary to pass laws and create the tools and do the advocacy to make sure that our democracy continues to remain resilient in the face of that threat that we continue to face.
Thank you so much. Gary?
I would hope that people take away that the very same leaders who were trying to claim that the 2020 presidential election was rigged are the ones who were trying to rig it by attempting to intimidate election workers into giving false testimony and attempting to gain unauthorized access to voting machines and mess with them. So I hope people would take away that that's really what happened, and don't even think about threatening and intimidating election workers.
Thank you. Andrew?
I'm gonna steal this from something that Judge Luttig has been saying, which is that this discussion and the debate we're having and what we're confronting here, in spite of what Donald Trump would like to say and have you believe, is not about politics. This is not about a conservative agenda versus a liberal agenda. It's not about whether you prefer Joseph Biden's policies versus Donald Trump's policies. It is just not about politics. This is about our democracy. And it's actually an issue, as Sean pointed out, that's bigger than just Donald Trump. If he has gone away tomorrow, we would still have this fundamental problem in this country that is, I think, going to be the challenge of our lifetime. And it's wrong to view this through the lens of Republicans versus Democrats. As Judge Luttig said, there really is no Republican Party left anymore that he knew and was a leader of. And it's really important to think about it in terms of an adherence to democracy and the rule of law.
The fight for democracy is at the heart of our history as a country. Our democracy is worth fighting for. It's at the center of our debate, the center of our discussions, as it should be. And this conversation is part of the mass mobilization of conscience and understanding that is in some ways the greatest bulwark we have. Here and all around the world, democracy is what we need to fight for. And it's great to be with such thoughtful and committed people to unpack not just these trials of the century, but the issue of our time. I want to thank them. I want to thank all of you for watching. For those of you who want to keep up with the work the Brennan Center does on these issues and on so much more, please consider signing up for our newsletters. They are spam-free. They're full of facts and links, and you can sign up at brennancenter.org/briefing. And our next event is on September 19th, which is on state courts, which are themselves a really important independent bulwark for freedom and equality in our country. The issue is abortion rights and the future of state constitutions. So please go to brennancenter.org/events if you'd like to register. Again, I am Michael Waldman, President and CEO of the Brennan Center for Justice at NYU School of Law. Thank you all for joining us, and have a good day.